This bill, it's an omnibus bill reforming the entire spectrum of our bail process. Unfortunately, it was set off by the murder of 4 police officers by a man who was on bail. The governor, law enforcement, generally felt that we needed to do something about bail. In turn, it turns out that there are a few things we could have done about bail, and almost by accident, we're doing those things. We could have done them with or without the murder of 4 officers. We're making we created a constitutional amendment, the people passed it last November, that allows judges to deny bail in a case of a dangerous person whose release would cause a real danger to the population generally or to a particular person, typically a witness. In that case, as in capital cases, these are the serious ones, the judge can deny bail altogether because of the danger that that person poses by clear, cogent, and convincing evidence. Even where bail is granted, we found out that there are some ways in which it's unfair. For example, we have 2 different kinds of bail bonds people, those who issue a property bond and those who issue really what amounts to an insurance policy. You pay the premium, you don't get it back. They, in turn, issue a policy that covers your risk. The risk being that the bond is going to be called into question if you don't show up. They, in turn, if you don't show up, can go find you, bring you back, put you back in custody, and get their money back. It's simply a method for making sure that people show. There are some, unfortunately, who would prefer that we have a mandatory minimum rate. In other words, price fixing. That the state should set a mandatory 10% price, so that if the judge says your bond is $100,000, you will be charged $10,000, which you won't get back, and the company can't give you a discount, even though, for example, you may be a lower risk. You may be somebody who's employed, have family here, you're not a flight risk. You may have property that's being put up either by you yourself or somebody, typically family, in your name. Doesn't matter. Even though the risk is much lower, the rate would be the same. I find that's unfair for a couple of reasons. One is price fixing generally. The consumer, any consumer, ought to be able to go from here to there and ask for a lower rate, compare rates, and go with a better one. More importantly, in our district, in the 37th, and in Seattle generally, where we have a significant low-income population, this particular kind of price fixing really afflicts low-income people who are, unfortunately, I hate to say this, more often the customers of bail bondsmen. More of the people accused of crime are low-income people. That's a fact. I'm not making this up. I think people understand that. Why should those people be deprived of the right to shop? Why should price fixing in any case be created, but certainly not where the people it afflicts are low-income people? And let me tell you, these individuals are presumed innocent, just like anybody else. They are constitutionally presumed innocent. You know, I've talked to some colleagues here in Olympia, and they say, well, yeah, I know, Adam, yeah, presumed innocent, yeah, but we know they did it. No, I'm sorry. We don't know they did it. And if a jury has not yet found them guilty, or a judge has not yet found them guilty, they're innocent. And if we believe otherwise, if we treat them otherwise, we are not being Americans. We are not abiding by our Constitution. Our Constitution says presumed innocent, and damn it, we need to treat them that way. We have had a spate of killings and injuries caused by police officers here in Seattle. We're not alone, by the way. Spokane has had the same problem lately. An uptick in the number of incidences within a short period of time. I don't think there's anything in the water. I think this is probably a statistical anomaly, but the fact is we need to do something, hopefully to prevent these things, but it's human nature. It's officers armed with a weapon and there are unfortunately encounters that they have with individuals that lead to violence. I'd like to be able to say we have a magic wand and we can prevent it. There are some things we can do. We can increase the part of their police officers' training curriculum that deals with the use of violence and its consequences, and we are doing that. There's another thing we can do, and that is, it doesn't help to prevent them, but when they happen, it allows the public to understand exactly what happened. And that is the process called an inquest. It's an old common law process. It goes back many, many centuries. King County has it by ordinance. And every county executive, since John Spellman, has invoked this process on every single occasion in which a police officer has injured or killed a civilian, or where a correctional officer has injured or killed an inmate. The way it operates is this. It's a jury of 6 people chosen from the voter rolls in the courthouse, same way any jury is chosen. There's no lawsuit, though. There's no plaintiff and respondent. Nobody's accused of anything. No order is going to come out of these people. Rather, their job is to find specific facts. Those facts are asked of them by a judge. And they give a yes or no answer to every specific question. They don't ramble on, they don't give a verbal answer, they answer simply yes or no. So the question has to be broken down. To use the example of the recent killing of a gentleman by the name of John T. Williams at the corner of Bourne and Howell Streets, the questions might be this. Was John T. Williams walking eastbound on Howell Street? Did Officer Burke stop his vehicle? Did Officer Burke approach Mr. Williams? Did Mr. Williams have anything in his hand? If the answer is yes, did he have in his hand the following objects? A knife, a comb, a wallet. If it was a knife, was the knife open or closed? You get the idea. These are questions that focus down through a system of yeses and nos to what really happened there. And by reconstructing those answers, putting them together, you get a picture. 2 major advantages of this. One, in our district, the 37th, Southeast Seattle, many of us feel frequently victimized for reasons of race or economic class by police officers. We feel that police officers are often after us. Historically, that's been true. I'm sorry, that has been true. Whether it is currently true, we grumble, we mumble. Sometimes we're right, sometimes we're wrong. Isn't it to the advantage of the police to have the public know that? Especially when, if the police will tell you, in most of the cases, they're cleared, that is, justification is found. If justification is found in most of the cases, my guess is that the police ought to accept this as a way for that fact to become better known. It is in King County because every executive since Spellman has done this. It's not in most counties. No other county does this on a routine basis. This would allow the prosecutors to do that. Second benefit of it is that it actually has a chance to reduce litigation. Litigation is a very expensive way of finding out what the facts were. This does that. In the county's expenses, a major one is defending against lawsuits. Any reasonable lawyer, and I've done this kind of work myself, who wants to sue the county or the city is going to wait for the inquest. The inquest shows very plainly that there is no likely success. There's no real cause of action here. Why not decide not to litigate? And if there is a cause of action, if somebody was killed or severely injured by an officer, there ought to be a lawsuit. That person ought to be able to find compensation from the county. So on those 2 grounds, on its ability to deal with lawsuits and on its ability to allow the people to know what their government agents are doing, I believe this is something that the public will benefit from.